time frame for our presentations. How much time do we have? Because that's not
I
clear
think
for
that
me.
there are no limits, probably. It depends on the decision of Professor Janusz Pol, of course, but I think there are no limits.
Okay, I will try to, nevertheless, to be brief and concise. Today, I would like to share with you some information about the international legal framework applicable to cross-border child abduction cases. And I hope it will give us some starting point to further research and to further discussion on mediation in such cases. I believe that in this research group, already much has been said and will be said mediation and the definition of mediation. But since I've just joined the project, and since it's an interdisciplinary term, and there is a great number of different definitions of mediation, I would like to start by proposing a working description of mediation, which I will be using in my further research and in my presentation. So I propose to understand mediation as a voluntary and confidential process of dispute resolution through which parties can reach their own agreements, which are not legally binding. Mediation is undertaken with the assistance of a third person, a qualified mediator, who is impartial, independent, and neutral. This working definition, as you can see, is based on the generally accepted principles of mediation process. Mediation is an alternative to litigation, so it's an alternative dispute resolution tool. Mediation can be court-based when it is offered either by mediators working for the court or by judges, and it can also take place out of court when it is operated by individuals or private organizations which are not directly linked to the court. I believe that it is the notion of cross-border child abduction that may need some explanation here. By cross-border child abduction, we mean the kidnapping of a child by an adult without the consent of the other parent or against a court decision, which results in the transfer of the child abroad and which affects the child's place of habitual residence. Cross-border child abduction may take the form of a wrongful removal, which occurs when a parent takes the child or children to another country without the consent of the other parent before leaving. Cross-border child abduction may also occur when a parent has given his or her consent for the other parent to take the child abroad, for example, for a vacation or a family visit, but the child stays in a foreign country for a period of time longer than the period for which a consent has been given and doesn't come back, basically. In that case, it is referred to as wrongful or unlawful retention. We can know that cross-border child abduction is sometimes referred to as parental kidnapping, but I think it is not entirely precise usage of this term, because in some rare cases, adults other than parents kidnap the child. For example, its grandparents. Under the relevant international instruments, the parent, without whose consent the child has been taken abroad or retained abroad, has the right to seek the return of the child. In cases where custody rights are exercised not by the biological parents, but by, for example, a child welfare institution, it is the institution who has the right to seek return of the child. wrongfully taken by one of the parents to a foreign country. We know that such cases occur, and in Poland, for example, they generate a lot of public attention. When a foreign institution, for example, the German Jugendamt or Norwegian Barnevernet, seeks the return of a Polish child taken to Poland by his mother or father who are deprived of custody rights. In the international community, the problem of cross-border child abduction started to be discussed somewhere in 1970s against the background of the growing mobility of persons across borders and the increasing number of binational families. This has led to the growing number of divorces with cross-border element and also to the growing number of international child kidnapping cases. This tendency, unfortunately, continues. According to the statistics that I have recently read, in Europe alone, there are over 170,000 binational divorces every year. Globally, there are more than 100,000 child abductions every year. On the international level, the issue of child kidnapping has been dealt with primarily by the Hague Conference on Private International Law, under the auspices of which the Convention on the Civil Aspects of International Child Abduction was adopted in 1980. And it entered into force in 1983. And it, up to this day, remains the main legal instrument in this field. Several regional international organizations also have dealt with the issue of cross-border child abductions. On the European level, it was the Council of Europe and the European Union who dealt with this subject. On the American level, it was the Organization of American States. Each of these organizations has developed multilateral international instruments which seek to give legal response to child kidnapping. As I have already mentioned, the main legal instrument with the greatest practical impact is the Hague Convention on the Civil Aspects of International Child Abduction from 1980. This is mainly due to the large number of ratifications, right now 101, but also to the fact that it establishes effective international cooperation between administrative and judicial authorities of the contracting states. And it lays down main rules of procedure that every state party to the convention has to follow. From the very beginning, child abduction was considered a wrongful act, which should be denied any recognition in international law. The 1980 Hague Convention is therefore based on the assumption that the abduction and the situation it creates is against the best interest of a child, and that the child's welfare is best protected by a quick response to such a wrongful act, unlawful removal. That is why one of the main objectives of the Convention is to ensure the fast and almost automatic return of the displaced child to the country of his or her habitual residence. The court competent to order the return of the child is the court of the state which the child has been illegally taken to or retained in. Such court, however, usually, as a rule, does not have jurisdiction to decide on substantive issues such as parental custody or contacts. In other words, the main goal of the Hague Convention from 1980 is to restore the status quo from before the abduction of the child as quickly as possible, so that the child could return to his or her familiar environment, where another court will decide upon the custody rights and other family issues. Here, let me point to, I think, a very important factor. In 1970s, during the time when the Hague Convention was drafted, around 70% of abducting parents were non-custodial fathers who kidnapped children from their mothers. So the almost automatic return mechanism provided for by the Hague Convention led in most cases to the returning of the child to the mother. However, the situation has changed significantly, and this proportion has completely been reversed. According to statistics, in 2003, 68%, and in 2015, more than 70% of abducting parents were mothers. So this change significantly affects the practical application of the 1980 Convention. Nowadays, the return mechanism laid down in the Hague Convention often leads to obligatory returning of the abducted child to the father and the separation of the child from the mother, who was the abductor. So it is a completely different result from that which was envisaged during the drafting of the Convention, and it raises concerns about the child's best interests and the application of the instrument. And it is here, after this long introduction about the Hague Convention, that I would like to touch upon mediation in cross-border child abduction proceedings. I believe that we all have heard about the advantages of mediation, especially in family matters. However, within the context of the return proceedings under the Hague Convention, mediation is even more important. Its significance definitely cannot be overestimated. Apart from the obvious advantages of mediation, like improving communication between parties, the win-win outcome, in the Hague child abduction proceedings, mediation offers a possibility for the parents to agree upon maybe different family arrangements than those that would result if the Hague Convention was applied. So as I mentioned, there is this risk of the separation of a child from its primary carer, taking into consideration the nowadays typical abduction case. So such arrangements that may be agreed upon by the parents in the mediation proceedings may be even more beneficial from the point of view of all the parties concerned, and especially from the point of view of the child's best interest. The Hague Convention itself does not refer to mediation, but it lays down the obligation of state authorities to take all appropriate measures to obtain voluntary return of the child or to bring about an amicable solution of the issues. Mediation is concerned as one of the ways through which voluntary return or amicable solution may be achieved. In 2001, the Special Commission of the Hague Conference, which periodically reviews the practical operation of the 1980 Hague Convention, recognized for the first time the significance of mediation for the convention mechanism. Since then, mediation has gained more and more recognition in the work of the Hague Conference and its bodies. In 2012, a Guide to Good Practice was published concerning the mediation. It is a very detailed practical document which deals with legal and practical issues connected to mediation under the Hague return proceedings, such as the scope of the mediation in such cases, models of mediation on the involvement of the child, or rendering the mediated agreement enforceable. If we compare cross-border family mediation to, let's say, regular domestic mediation in family matters, we can see that mediation in international child abduction cases needs to deal with some very specific challenges. First of all, it needs to fit into the very tight time frame prescribed by the Hague Convention. The court proceedings concerning the return of the abducted child should be completed within 6 weeks' time, and that is the deadline within which the mediation also shall take place. So compared to the regular domestic mediation in family matters, which usually takes weeks or even months, it's a completely different time frame. Mediation in cross-border child abduction cases can take place at the stage of judicial proceedings, and it can be either court-based or it can take place out of court. It can as well be initiated before the court proceeding is launched, for example, upon a recommendation from the central authority. There is no uniform practice or international model on how to integrate mediation into court proceedings under the Hague Convention. It depends on each country's domestic regulations. Nevertheless, there are some interesting models or propositions developed by non-governmental organizations dealing with mediation in cross-border family cases, like the German MIC organization or Reunite in Great Britain. I will try to present these models in my chapter. Another characteristic feature of cross-border child abduction cases is that mediation in such cases takes place against the background of a highly escalated conflict and usually bicultural, bilingual environment, which requires from the mediators specialized training and language competences. Last but not least, mediation in cross-border abduction cases needs to consider complex issues of applicable law and jurisdiction. Ideally, if the conflicted parents reach an agreement during mediation, such agreement should become legally binding and enforceable, the first step of which is usually an approval by the court or incorporating the mediated agreement in a court order. However, apart from the question of return or non-return of the abducted child, parents often discuss several other family matters in such mediation, such as custody rights, contact and access, relocation, child maintenance issues. And all these issues are regulated under different international instruments and may belong to different jurisdictions, which make the recognition and enforceability of mediated agreements a highly complicated legal issue. It is sometimes complicated on the domestic level to render mediated agreement enforceable, and not to mention the cases with transboundary element. It is nevertheless a crucial issue for the application of mediation in cross-border family cases, that the mediated agreement could be rendered enforceable in all the countries concerned. For some years now, the recognition and enforceability of mediated agreements has been the subject of concern of the Hague Conference on Private International Law and, of course, the European Union as well. I will come back to it during our next seminars when I discuss legal instruments for the cross-border family mediation adopted within the European Union. I would like to mention one more thing, that it is worth noticing that the legal framework for mediation in cross-border child abduction cases is first of all based upon the provisions of the 1980 Hague Convention, as I mentioned, but it is not the only legal order, let's say, that applies here. because this framework also includes the relevant domestic law of the concerned states, governing both the application of the Hague Convention and the mediation process itself. It also encompasses all the rules of international private law and domestic legal orders regulating the recognition and enforceability of mediated agreements. So, as we can see, the practical application of mediation under the 1980 Hague Proceedings is a complex legal issue, albeit a very exciting and challenging one. Thank you very much for your attention.
Thank you very much, Katarzyna. And I can take my role as a chairing person. So I'm very sorry of my delay, but I couldn't open nor my camera, neither my microphone. So I should reset my computer. So I'm back with you. And of course, following our schedule for today, and so inquiring the legal framework and the basic problems of mediation, with this crucial aim for us, looking for common perspective or sharing our experiences of mediation. The floor goes to Professor Richter, who's going to deal with his topic connected with administrative law, so administrative jurisdiction and mediation. Please, Professor Richter. And I see that your presentation is already open. If not, I can always help you because our assistant shared with me the authorization to open the presentation when they were sent before, so I can help you if any problem arises. Thank you, Adam.
Thank you very much, Barbara. Good evening, dear colleagues, and thank you, Katarzyna, for your excellent presentation. I worked for a family care center as a lawyer almost 2 decades ago, and I know how important and how tough this issue was and is still. My presentation on the legal background of mediation within administrative court proceedings consists of 2 parts, as you can see on my only slide. The first one is the introduction of the main rules on mediation in administrative procedures in Hungary, and the second one provides a comparison between the main rules of mediation within criminal court procedure, civil court procedure, and administrative court procedure in Hungary. I hope that the second point makes the connection between our researches, I mean between the researchers within this research group, stronger. First, let's begin with the important fact that the Hungarian administrative procedure was transformed by the new Act of 2016 on the Code of General Administrative Procedure. The system of judicial review has been changed radically by this act. The intra-administrative remedy, the administrative appeal against the first instance decisions of an authority, has become only an extraordinary type of the remedies, because in principle, the first instance cases could be challenged by an appeal only in the cases defined by an act of parliament. The judicial review of the administrative decisions has become the major remedy against the acts of the authorities. Searching for those certain legal institutions that are closely connected with settlements reached within administrative procedures, we can detect such institutions both in the Act on the Code of General Administrative Procedure and within the Act, the first Act of 2017 on the Code of Administrative Court Procedure. You can see them on my slide as well. Mentioning only the general rules, because there are also specific proceedings of certain fields of public administration, the 4th section of the Act on the Code of General Administrative Procedure states that the authority, in order to effective, shall organize its activities so as to impose the least amount of expense upon all parties to the proceedings and to close out the proceedings as fast as possible. And one of those institutions that are able to satisfy these requirements within the given act is mentioned within the 75th section, that is the attempt at settlement, which says that if the authority holds a hearing, at the hearing the authority shall attempt to mediate a settlement between the adverse parties. And a little bit later it also states that if a settlement is agreed upon, or if the clients enter into an agreement and the settlement is in conformity with the fundamental law and other legislation, it provides also for the performance deadlines and for covering procedural costs. The authority shall approve it and shall transcribe it in a resolution. There are several further provisions on the approval of settlement as well, but I'm not going into the details. The act, the first act of 2017 on the Code of Administrative Court Procedure allows us 3 possible ways of reaching a settlement. The first one is a settlement initiated and approved by the court without mediators. The second one is a settlement initiated by the parties and approved by the court with or without professional mediators. And the most exciting for us, the third one, is when the court mediation itself, the court mediation itself, that is special because the mediator is a professional judge who is not a member of the panel that hears the case. In the written form of my presentation, I mean within my chapter, I'm going to summarize the most important rules of the ordinary settlements, but now I have to turn to the court mediation because of the time limits, so I will concentrate only the third one, the court mediation. Within the framework of the court mediation, the court shall order mediation if the parties and the interested persons have consented to it. During mediation, the parties and interested persons make an attempt to settle the legal dispute with the involvement of the court. The court shall suspend the procedure until mediation has been completed, but for 2 months at most. Section 70 states that the court mediator shall not be a member of the panel that hears the case, as I have already mentioned, and that the proceeding court shall examine the settlement and, if it complies with the laws, incorporate it into an order with the effect of a judgment. If mediation is completed without a settlement covering the whole legal dispute, the proceeding court shall continue the procedure under the general rules. So, these are the most basic rules of settlements that can be reached within administrative proceedings. But the real importance of these features could be shown by comparing the particularities of those settlements, especially of those that are reached by the usage of rules of administrative court procedure, with that of criminal court procedure and civil court procedure. My comparison is not a complete one, introducing all the possible aspects. I concentrate only on the 6 more important or most important factors that could be helpful, even though the conclusions are results of generalizations and simplifications to some extent. My first observation, or my first point, is about the role of those courts acting in these fields. It's quite obvious that the role of a court acting in the field of administrative law is quite different to that in private law, due to the fact that the role of an administrative authority differs substantially from that of a private party, at least to the extent that an administrative authority is strongly bound by the principle of legality. It may still be allowed some discretion, but it lacks the full amount of private autonomy. In other words, the yardstick of the judicial review, the law used, is not at the party's disposal. It means that the content of any settlement is strongly determined by the extent of the legal discretion provided by the law to the given administrative authority. My second point is about the existence of mandatory mediation within those three fields. There are no mandatory forms of mediation within the administrative and criminal court procedures in Hungary, and there is only one within the civil court procedure. Act 5 of 2013 on the Civil Code states that in justified cases, the court may order the parents to avail of a mediation procedure in the interest of the proper exercise of parental custody and of the cooperation between them required for the former. My third point, or it's better to say that my third question is that, or whether everyone is interested in reaching settlements through mediation within court proceedings. Are all the parties interested in reaching settlements through mediation within these court proceedings? The so-called win-win philosophy of the mediation reflects the ideology of mutual benefits, the satisfaction of mutual interests, and even the conclusion of strategic alliances that is inherent to the mediation institution. Within criminal and civil law cases, this logic can be justified easily. But in administrative court cases, it is not so easy to prove that. Why should the representative of a given administrative authority accept any changes within the decision in question if there are no legal obligations to do so? There are some answers, but none of them is so obvious as in criminal and civil cases. And I will go into the details next time about those answers. My fourth question is that at which stages of the procedure is mediation allowed within those fields? Within criminal court proceedings, mediation is permitted only at a stage before or prior the issue of an indictment against the person suspected of a crime. In civil law and administrative law court proceedings, it works differently. Mediation can be used at any stage of those disputes. My fifth question was that what is the whole mediation about? Because it's also an important question, because within an administrative court proceeding, the parties are not trying to negotiate about the lawfulness of the decision in question, but they are seeking for a solution within the frameworks of the discretionary powers of the defendant, of the administrative authority. On the contrary, within mediation in criminal court cases, the perpetrator admits the violation of the law, and the only question is the form or the extent of the compensation. And my last question is, why is the increase of mediation so slow in all the fields mentioned? Why do the numbers remain so low? The number of mediation proceedings showed an upward trend in Hungary in the beginning of this century in general, then stagnated in general, or have been even decreasing in some fields, not all fields, but in some fields. The question inevitably arises as to what is the reason for this. The explanation, in my view, is much more to be found in the fact that the new courts and other legal sources have introduced a number of rules aimed at speeding up proceedings, which are sometimes applied instead of mediation proceedings. Some of you were already there 2 hours ago when Kitty Pollak was speaking about this issue, mentioning some forms, telling us that there are several institutions that accelerate the receiving of a final decision within an administrative court proceeding. She mentioned simplified procedures and some other forms also. Moreover, each and every new rule related to mediation makes the process more complex and less transparent for the parties, for the possible parties. It's a kind of a paradox in the mediation, the result of which is that the forms of and the rules of the mediation have been doubled or tripled in the last few years or decades, but the numbers of those processes have not. Thank you very much for your attention.
Thank you very much, Adam and Professor Rixer. And I really highly appreciate your impact into the criminal law, as we all discuss the aspect of criminal law, and you are now very so you can be included in our research, I see. So you are doing your best to fit in our monograph. The same I can say to Dr. Zambori. So now we start with the criminal law aspects, but firstly it would be Dr. Peno. Yes, Dr. Peno is the third. I need to check, but I'm almost.
Yes, sure. I'm here.
Yes, and because when I thought about our seminar for today, I tried to start by Katarzyna Zambori because she wasn't present with us before, so she get quite a lot of time to discuss with us. So now I'm trying to insert some discipline with our speech. Then we had this presentation of Professor Rixer, and now the floor goes to Dr. Peno. He's going to deal with us about restitutive justice. So please, if you would like to open the presentation, you can do it by yourself, or I can help you.
Yes, I'm trying to.
I can do it. So.
Yeah, I think that here is whole ekran. Okay. I guess that now we can see my presentation.
Yes, it works.
Am I correct?
The floor is yours.
Okay, thank you.
And 15 minutes. So try to be strict with time because we started with delay. And
excellent.
And I
okay,
hope that at the end we will have discussion.
Okay. Okay, so may I will start with a very general question. I must add only that I will speak of restorative justice in reference to the concept that has been introduced earlier during our last seminar. But well, speaking generally, I will concentrate on mediation, which can be considered as a kind of form of restorative justice or technique. So my general question is, why do we need mediation? Why do we need mediation? And I would say that from the point of view of a legislator, these are two types of motivation to introduce this institution, mediation, or speaking broader, restorative justice. Of course, I will explain these two motivations during my presentation. what I can add here is that sociology, especially the sociology of law, is dominated by the authorized right belief that law is an important instrument of social control. This belief states that by means of legal measure, it is possible to purposefully and effectively influence human behavior or attitudes, both individually and collectively. And here we have two, I think, typical reasons. Instrumental, that means that law is an important instrument of social control, or for the sake of values. But how to understand that the reason for changes in the law may be values? Here I will try to explain restorative justice in the category of a legal institution. This legal institution based on conversation, understanding, commitment of the perpetrator, victim, community, and facilitators. I would like to reflect on why we believe that the law should be changed to a more consensual one, and the emphasis should be shifted to the mediation, or more broadly, restorative justice. My question is, why do we want to strengthen, support, and promote institutions such as mediation? What is its justification, rationale? And of course, when I'm talking about restorative justice, I refer to specific institutional solutions like mediation, conciliation circles, quasi-mediation. Of course, changing the law must involve the social context and the axiology. Here when we talk about restorative justice as a kind of legal institution based on conversation, understanding, commitment, and so on, here we have values. When we talk about a certain concept of restorative justice, we are referring to certain values. These values result from the very conception or idea of restorative justice and also mediation. These are values taken from the ethics, the so-called ethics of care, which gives moral significance to our personal relationships. And I think that these values are quite good visible in this context. Now, one sentence more about legal institution or a set of legal institutions. So let me start with the fact that when we are talking about mediation from the point of view of legislator, or more broadly, restorative justice, we are basically talking about some legal institutions. In the light of legal sciences, a legal institution, of course, is a separate and functional whole set of legal norms relating to relations in some area of social life. The legislator should be interested in the issue of the appropriate shaping of legal institutions in the normative aspects. This is normative aspect, but obviously one should not forget about the effectiveness of the law. That is about the operation of legal institutions. When we project legal institutions, we have to answer the question of goals, and goals are closely related to values. Here we have a model or steps. And the model of rational lawmaking proposed in Polish legal theory. And here we have 5 elements of this model. This is my own reconstruction of this model of rational lawmaking process. So here we have 5, or if you want, the last one is, of course, is quite obvious. We have to enact a projected law. But look at the First one, setting up and defining a sufficiently precise goal. Here I will give you time to read these 5 points. A sufficiently precisely defined goal is one that enables the selection of means for its implementation. And I will concentrate now on the first step. In this presentation, the focus is on purpose or value. I have time? Okay. Okay. Goals are values. According to the model of rational, this model of creating or projecting law, goals are values. And of course, yeah, it's quite obvious, but it is important to highlight this this point. Goals are values that the legislator intends to pursue. I would like to I would like to concentrate on the aim or goal and motives of the legislator. Legislator can be understood in many ways. Of course, this does not.
Okay, so I can see that Dr. Penna has some technical issues, like I suppose internet connection has failed. So let's wait for him, I suppose, 2 minutes to not be stressed. I see that today we have to keep our nerves of steel with all these technical issues and this complication with the starting of the seminar. So I think that the best way is to wait right now for Dr. Penna, because he's in the middle of his presentation. During maybe this time that I can share with you, waiting for Dr. Penna to join us, I can maybe add some thumbs up after 2 first presentation, especially the presentation of Professor Rixer, because he touched the field we are discussing right now, the criminal law aspect of mediation. And it was very important what Professor Rixer has underlined, that mediation in the field of criminal law, because it could be in some point linked with the presentation of Dr. Zombori, because cross-border child abduction, it is also the matter, the issue connected with criminal law. So, but what is important is that mediation in the field of criminal law, it is an institution which could be in favor of defendant, but only under the condition that defender has agreed and has confessed, at minimum admitted guilt. So it is very important, because it maybe it is not a best option for defendant, for the perpetrator in criminal cases. So as Professor Rixer discussed about this field, about the subject of mediation, and pointing out that at the field of criminal law, the question of the fact of responsibility is not discussed. It is very important question, but maybe we can then discuss and maybe think after our seminar, maybe because I have these thoughts that maybe this is an aspect why mediation is not so effective in the field of criminal law. Maybe perpetrator is not so interested by admitting guilty at the first step of procedure, during pre-trial procedure, because it is a necessary condition to discuss then and take a rule of the person under mediation. So I see Dr. Penna, who is with us. Dr. Penna, are you with us? Don't be stressed, we are waiting for you. because I see that the technical issues are more complicated. Maybe it is something about the weather in Szczecin. So maybe there's storm, or I cannot see Dr. Penno. Maybe I will check our discussion, if you don't mind, on WhatsApp. Maybe I have some updates of Dr. Penno. No, any information. So it's just 3 minutes, so maybe someone would like to give us some feedback. Maybe we because we have some publics, some guests, and maybe there are some questions to the first presentation and the half of presentation of Dr. Penno. If someone is interested to enter into discussion, you can write your question down on the chat and I can read it aloud, or I don't know about the technical issue that whether you are authorized to speak as a just participant, but maybe someone is interested to discuss this issue. But to concluding my thoughts about the previous presentation, so I think that it's very important the aspect of the extent of mediation. So what is the extent to negotiate and by whom, like Professor Richter and Dr. Katarzyna Zombory indicated that those who are authorized to negotiate are different interests following different field of law, private and public law. Even if I'm not fully agreed with Professor Richter that in the field of criminal law it's so obvious to discuss and elaborate the interest, because interest of victim it is not fully interest of society, of public prosecutor, so this public interest. So it is not so easy to oh, we have Dr. Penno. So I'm trying to keeping small chat with our group while waiting for you.
Okay, I'm really sorry. I have a problem with connection. So now I sent, if it would be, I don't know whether it would be possible, but I can send you my presentation.
Oh, no, I have this presentation, I suppose. There is here. No, standards of judicial review. It's not yours. Okay. Okay, so there is not, your presentation hasn't been sent before. So it's the best way to go without presentation right now, I suppose, if you cannot share it with us.
No, I can, but I know whether I have time. If yes, it would be, of course, lovely to show you my presentation. So now you can see it.
Okay, let's try.
Yes, okay, thank you. And I'm really, really sorry.
Don't worry, it happens.
Okay, so it's a big technical problem. Okay, so let's back to the presentation. I mentioned that the important axiological aspect of every restorative justice conception is that personal relationships are considered as a kind of moral value. So one of the challenges of instrumentalism appears here. What if the legislator recognizes certain values, but they are not recognized by the majority or part of society? Should the legislator educate and shape the society, or only describe according to what can be empirically examined, only describe the current state of affairs, the current morality? Most restorative justice concepts are based on the strong premise that moral education is part of all restorative justice programs or institutions. I'm not sure if Polish society prefers consensual methods recognizes the authority of mediator or facilitator and needs solutions proposed by restorative justice. Is it possible to impose these values? And is it not a kind of manipulation in the sense that we are trying to shift morality on a different track? Does the legislator have the right to do so? So, educate and shape the society or only describe the current state? Narrow technical regulation or wider social change? This is not the only problem. When developing legal institutions based on mediation, agreement, consensus, we also have to consider whether they are an intrinsic or instrumental value for us. The scope of this institution will be different in each case. So, what I wanted to say is on this slide, when designing restorative justice institutions, this form of action, this form of process is considered valuable. But what is the basis for the recognition that restorative justice, including its techniques such as mediation, is a value? There are two possible answers to this question, as there are two approaches to the implementing restorative justice institutions. We deal with a system rarely today because systemic presupposes the separation of an ordered set or class of norms and moral judgments. Of course, A is here. Here we have A is a value in relation to a certain set of values. Yeah, so we have to decide whether for us restorative justice or mediation is or has a value as a or instrumental value, or it is a value itself. For me, it's a very important question. So, is the institution of restorative justice a goal and value to do to one set of values or another, or is it a means of attaining some other state of affairs desired by the legislator? If mediation or restorative justice is an intrinsic value for us, then we will support and promote these institutions independently of other goals, such as speeding up court proceedings, reducing the costs of court proceedings, improving the public services, etc. This is an important issue, I think. On the other hand, if we want to achieve a state of affairs by these institutions, we must specify the state, this state of affairs and goal, keep this goal in front of our eyes and consider whether the proposed institution can achieve this goal. I don't know. I'm sorry. And of course, finally, it remains to be considered whether the legislator really wants to introduce such values. Perhaps the goal is only to speed up court proceedings, lower costs, and better statistics. So utility, productivity, economy, and success needed for a parliamentary elections, it is not a goal. We have to precise what is our goal, and we have to decide whether for us this kind of institution, restorative justice mediation, as a one of technique, which is typical for restorative justice, it is a value itself or it is an instrumental value. We have to precise goal. We have to precise what we actually need, what we want to do by these institutions. So for me now, at this moment in time, from the point of view of Polish legislation, from the point of view of Polish legal system, we are here on the first step. We have to define precise goal. we have to decide whether mediation and these values are important because we believe that these values are important for our society, or we need to achieve other goals. So, thank you
Okay, Dr.
very
Peno.
much. I hope that.
Yes, could we conclude? Okay, because now I cannot hear you anymore. So, but this is a moment that we could share the floor with the next speaker, Dr. Kowalewska-Łukuć. Dr. Kowalewska-Łukuć is going to present the crucial problems of mediation. So I think that following, thank you, Dr. Peno, one more time. I couldn't find you anymore. So now is the place for Dr. Łukuć.
Thank you.
Okay? Thank you very much. So Dr. Łukuć, it's your time and the presentation is open. So please, the floor is yours.
Hello, thank you very much. Today I would like to say about crucial problems which we have in mediation in Polish criminal proceedings. At our July seminar, I presented the institution of mediation in Polish criminal proceedings in its de legalata form. I outlined the basic provisions of the Code of Criminal Procedure, which I call CCP, concerning mediation. I mean Article 23A, and the provisions of the regulation of Minister of Justice concerning the procedure of mediation. Just let me change the slide. I'm not sure if I can do it. I can, great. My conclusion at that time was the mediation regulation seems to be quite sensible and well considered. It should therefore work quite efficiently in Polish criminal proceedings and be used quite often. Meanwhile, statistics indicate that only a small number of criminal cases are submitted to mediation, specifically less than 1%. This may suggest the existence of some problems or limitations in the application of this institution. My working hypothesis at the time was that this might be due to so-called consensual modes of ending criminal proceedings, which are simply more attractive to the accused person than mediation itself. I would like to develop this hypothesis today. My second working hypothesis, which did not resonate at our last seminar, is that also the victim is not particularly interested in mediation in Polish criminal proceedings for the simple reason that he or she obtains very little from the mediation. Turning to first hypothesis, I formulated that the defendant in Polish criminal proceedings is not particularly interested in mediation. It seems that the current construction of the so-called conviction without trial, I mean Article 335 of the CCP, and voluntary submission to punishment, Article 387 of CCP, are more attractive for the accused and more easily accessible. When a defense counsel accepts his client's criminal case and the preparation and guilt are not in doubt and the facts are quite clear, the first thing, I suppose, the first thing that comes to the defense counsel's mind is precisely a conviction without trial or voluntary submission to punishment. These institutions are also attractive for the authorities conducting criminal proceedings, for the prosecutor and for the court. Sentencing without trial and voluntary submission to punishment win with mediation in the field of pragmatism. They cause criminal proceedings to end quickly in a manner acceptable to both the authority and the accused, which of course does not mean in a way that is favorable to the victim. One of the most frequently indicated advantages of consensual modes is significantly acceleration of criminal proceedings and limiting their costs. time and financial rationalization is very important here. Statistical data show that in the case of applying the institution of sentencing without trial, the majority of cases end at the first session. Another advantage is the convicted person's acceptance of the verdict and the punishment imposed on him or her, which seems to be very important for the individual preventive goals of the penalty. We may ask ourselves, however, where is the victim in the idea of restorative justice or the compensatory function of criminal law in general in all of this? Obviously, in the case of conviction without trial, the legally protected interests of the victim are required to be taken into account, and the granting of a request for a conviction without trial is possible if the victim does not oppose it. However, it is formally where his role ends. Victim does not formally have any influence on the final shape of the trial agreement. The situation is similar in the case of Article 387 of CCP and the institution of voluntary submission to penalty. Here as well, the victim may oppose the defendant's motion for a guilty verdict without taking evidence. Formally, however, the victim has no other means of influencing how the criminal proceedings will end. Meanwhile, if consensualism is to be an expression of a broader tendency to modify the continental model of proceedings, to focus on the resolution of the social conflict caused by the commission of a crime, it would seem that the person of the victim should be taken into account much more than in conviction without trial or involuntary submission to a penalty, even if we remain with the inquisitorial model of criminal proceedings. Mediation seems to be the answer to such a need. It gives, or maybe rather only can give, more possibilities to take into account the perspective of the victim. The mediation procedure and the agreement reached at its conclusion are not the result of negotiations between the defendant and the prosecutor or court, but precisely with the victim. And here arises the question how to redirect the popularity of conviction without trial to mediation. First idea that springs to my mind is to make mediation an element of consensual institutions. I mean, make the condition that the criminal case can end in consensual mode only after mediation. As I remember, Dr. Peno at our first seminar or maybe at our workshops mentioned something similar to this condition. What is lost here is a little bit of the speed of the proceedings. It will not be a single conversation with a prosecutor, but a mediation procedure, lasting only, however, I would remind, in principle, no longer than 1 month now, yes? So the result of mediation proceedings, including above all the settlement agreement, could then be taken into account in the final verdict of the criminal proceedings. The victim would then stop to be only the subject which accepts a consensual conviction, but would also become a participant in this conviction. A second idea on how to strengthen the role of mediation in criminal proceedings is to make it more attractive than other consensual modes. We had in Poland until 2016 the possibility to discontinue proceedings at the request of the victim, where the prerequisites were precisely the reconciliation of the offender with the victim and the reparation of damages, and all of these were determined mainly through mediation. Perhaps it is worth trying to return to this institution, especially as the removal of this provision has been met with rather fair criticism from the doctrine. The discontinuation of proceedings at the request of the victim appears first and foremost as some kind of benefit for the offender. It is the most far-reaching reduction of criminal responsibility, there being no conviction at all. Yeah? However, the offender could have more benefits from mediation. I'm thinking here of the psychological aspects of mediation. Some studies, maybe not even not some, but many studies show that after mediation, offenders have increased levels of compassion and empathy towards victims and decreased risk of recidivism. So it's a great result, yeah? However, I think it is also very worthwhile to look at what the victim can get out of mediation. I think that in order to make mediation more popular and make it a viable alternative in criminal proceedings to other forms of consensualism, it is necessary to take into account certain victimological and psychological aspects related to the victim. I indicated that my second working hypothesis is that also the victim is not particularly interested in mediation in Polish criminal proceedings. This interest could perhaps be increased by clearly showing the victim what he or she can get out of such mediation. To do this, it may be necessary to adapt mediation proceedings in a certain way by taking into account victimological and psychological aspects. I would like this issue to be subject of my paper at our September seminar. To conclude, in summary, in my view, there are two fundamental problems in the shape of mediation, the legal lata in Poland. Mediation loses with conviction without trial and voluntary submission to punishment. It is less popular, it seems to be less attractive for both the offender and for the procedural authorities, for the prosecutor and for the court as well. And mediation does not look particularly attractive to the victim either. So there is clearly a need to place more emphasis on what the victim can gain from mediation. What I would like to explore further in this connection, the possibility of turning to so-called victim-sensitive mediation, but all of this at our September seminar and probably later in the article. Thank you very much for your patience and for your attention. That's all from me for today.
Thank you, Dr. Kowaleska. It was very conclusive speech, so I suppose that we could discuss further maybe during discussion, if not during the next seminar, as you told. And now is the place for Dr. Ferenc Santa. His focus today is a victim. So it will start, I suppose, a long way for us to discuss the position of victim in those kind of mediation. And Hungarian perspective, we have the presentation already shared. So the floor is yours.
Yes, thank you very much, Barbara. I don't know that the PPT can be seen well.
Yes, very well. I
yes.
can see very well.
Okay, thank you very much. The title of my presentation is The Place of Mediation and the Role of Victim in the Hungarian Legal Justice System. And I have subtopics in this occasion. First of all, if you can see in the next slide, the subtopics are the criminal justice system of Hungary. The second is the role of the prosecutor and forms of diversion in Hungary. The third, the role of the victim in the procedure, and if I have time, the characteristics of restorative and retributive justice. So, if we can see the next slide, the first subtopic is the criminal justice system of Hungary. Maybe you can know that the two major criminal justice systems are the accusatorial and the inquisitorial system. The first was developed in common law countries where the court is an impartial referee between the prosecution and defense, and the aim is to establish the procedural truths, the so-called formal truths. The procedure starts usually at the request of the victim. The focus is on the judicial phase of the procedure, and the procedure is based on the principle of verbality and directness. The second, the inquisitorial system, was developed in civil law countries, where the procedure aims to establish the material truth, the objective truth. The principle of officiality is applied in the system. The investigative phase is the dominant part of the procedure, and literacy prevails rather than verbality. The current Hungarian system of criminal procedure belongs to a third system, the so-called continental mixed system, as it has the characteristics of both the accusatorial and the inquisitorial procedure. And if we can see the next slide, the characteristic features of the Hungarian mixed system are the following: the prevalence of the principles of officiality and legality, the emphasis on the investigation phase, and the aim of the proceedings of establishing the procedural truth. The principles of verbality and directness are applied. The trial is contradictory in nature, and the rights of the parties are regulated in detail. From the point of view of our topic, the most important issues are the principle of officiality and the principle of legality. The first, principle of officiality, means that where a crime is being suspected, the competent authorities are obliged to initiate and carry out the procedure ex officio without being bound by the consent of a third party, for example, the victim. The principle of legality in this context focuses on the obligation. The public prosecutor is obliged to prosecute all the crimes that he or she gets to know about. In Hungary, the basic principles of criminal procedure are legality and officiality, and the so-called mandatory prosecution, which means that in principle, every person who commits a crime is brought before the criminal court. But nowadays, based on the new criminal procedure code, the principle and practice of opportunity are significantly increasing, and the prosecutor has more and more discretionary power. What means principle of opportunity? It can be considered as a possibility available to the prosecutor not to prosecute all the criminal offenses that he or she gets to know about. And if you can see the next slide, the question must be asked why prosecutorial discretion and opportunist institutions are so important in the context of our topic. The answers and our statements are the following. The first answer, or the first statement: if the principle of legality is the general rule and opportunistic considerations are the exception, the procedural situation of the victim is different from that in the system where the criminal procedure is based on opportunism. The second statement: in Hungary, victim offender mediation and several other legal institutions that contain restorative elements are closely linked to the discretionary powers of the prosecutor and different forms of diversion. Furthermore, the close link between the requirement to accelerate, to speed up the criminal proceedings, and the need for victim reparation can also be identified in Hungary. And if we can see the next slide, the second subtopic of my presentation, the role of the prosecutor and forms of diversion in Hungary. The Public Prosecution Service and the Public Prosecutor play a key role in the Hungarian criminal justice system. The prosecutor is the public accuser. His or her tasks are wide-ranging, both in the investigative and in the court phase. In Hungary, the investigation phase has three parts: the preliminary procedure, the detection, and the final stage is the examination. It's very interesting that prosecution phase is no longer in Hungary, so the prosecutor has the possibility at the final stage of the investigation to decide how to continue the proceedings. At the end of the examination, at the end of the investigation, if the investigation is not terminated, the prosecutor has several options. Now I mentioned just two possible decisions. The first is the traditional way to deal with a criminal case, namely the prosecutor may file an indictment and the case will be adjudicated at a formal criminal trial. But, and this will be a citation from the website of the prosecution service, obvious and strategic aim of the prosecution service is to complete cases as quickly as possible, and only serious, complicated, and multi-party cases to be brought to court. So the second option in the handle of the prosecutor is applying the different form of diversion, which to a greater or lesser extent contain a restorative element. And we can see the next slide, the different forms of diversion. First of all, the admonition, the so-called reprimand, is this is the mildest criminal measure which may also be applied by the prosecutor if the perpetrator's conduct is no more dangerous for society. In assessing this condition, no more dangerous for the society, in addition to the lack of criminal record and the minor gravity of the offense, it is of great importance whether the offender has compensated the victim or otherwise made reparation. The second option of the prosecutor is the suspension of the procedure, more precisely the conditional prosecutorial suspension of the procedure, when the prosecutor may suspend the investigation for a specified time period if law-abiding behavior can be reasonably expected from the suspect. This form of diversion can only be applied, of course, in less serious cases. And the point is that the prosecutor may prescribe rules of behavior for the suspect, among others, to compensate the victim for the damage, loss of property, or loss of tax revenue caused by the crime, to ensure the compensation of the victim in another way, or to make a financial contribution to a specific purpose or perform community service. The third option in the handle of the prosecutor is the agreement on a guilty plea and its consequences. It's of course an agreement between the prosecutor and the suspect, which includes the facts of the case and the legal classification of the crime, the guilty plea of the suspect, and the sanction to be applied later on by the court, by the criminal court. Then the point is that the agreement may include other obligations undertaken by the offender. On this basis, the offender may undertake to satisfy the victim's civil claim or to compensate the victim for the damage or loss of property. And the fourth option of the prosecutor, of course, the victim-offender mediation process. I will talk about this topic in detail in the next presentation. So, as you can see, the prosecutor has a decisive, almost exclusive role in the use of restorative institutions in Hungary. As I mentioned earlier, the mediation process was also be possible in the court stage until the 1st of July 2018, but currently only the prosecutor may decide to transfer the case to mediation at investigative stage. The question is whether it was the right decision or not. You can see the next slide, the arguments in favor of this decision, at least according to the legislator, is that the most important tasks of mediation, namely the agreement between the victim and the perpetrator and reconciliation, can best be accomplished close to the time of the commission of the crime. Furthermore, it is a fact that the number of mediation proceedings ordered by the court has always been extremely low in Hungary. And agreements against this decision, I have to mention that in most European countries, mediation can be applied at any stage of the procedure. This is also in line with international trends. See, for example, the recent recommendation of the Committee of Ministers concerning restorative justice in criminal matters from 2018. According to the recommendation, restorative justice should be generally available service, which means that restorative justice should be available at all stages of the criminal justice process. On the other hand, by limiting mediation to the investigative stage, we are losing the possibility of mediation in cases where a compromise between the victim and the offender is reached only after the indictment. So, our proposal is that victim-offender mediation should also be applicable in the judicial phase of criminal proceedings. And we can see the next slide. Yes, the next subtopic, the role of the victim in the criminal procedure. Anna Kiss, she's a Hungarian expert. She wrote about 15 years ago. It will be a citation. In criminal proceedings, the victim is an insignificant person. He or she has little or no opportunity to shape the course of the procedure or influence its outcome. In the following, I would like to demonstrate that this situation has now changed, and the procedural role and protection of the victim have recently been significantly strengthened. Before the entry into the force of the new Criminal Procedure Code in 2018, Council Framework Decision in 2001 was the first legal act adopted by the European Union to lay down general provisions addressing victims of crime and their rights. It directly inspired the Hungarian legislator, since an act in 2006 made victim-offender mediation possible in Hungary. And a decade later, significant progress was achieved by adopting Directive 2012. This is the so-called Victims' Rights Directive. And now I would like to highlight just one provision concerning our topics. Member states shall ensure that victims who choose to participate in restorative justice processes have access to safe and competent restorative justice services. In 2015, the Hungarian legislature modified the Criminal Procedure Code and related acts in order to make the Hungarian legal system compatible with the directive. And we can see the next slide, the situation after the entry into force of the new Criminal Procedure Code. I would like to mention just two provisions. First of all, the preamble of the CPC, which explicitly states that special emphasis could be placed on the increased protection of victims and the enforcement of their rights. And the second is the explanation of the code, the general explanation of the code, which states that the new code places greater emphasis on the need to ensure that the victim fulfills an active and formative role in criminal proceedings. In order to meet this requirement, like other participants of the procedure, the Criminal Procedure Code clearly and explicitly defines the procedural rights of the victim. This is very important because the provisions concerning the victim were previously placed in different parts of the CPC. Currently, the code provides the definition of the victim and regulates all the rights of the victim in a separate chapter. You can see in the slide the definition of victim, but I have to continue the next slide. The rights of the victim, of course, I mentioned just a few of them. First of all, a new legal institution in Hungarian criminal procedure law, the so-called declaration of the victim. It means that the victim has the right to declare at any time what physical or mental harm or what material damage he or she has suffered, and whether he or she wishes the perpetrator to be found guilty and punished. The second is the right to withdraw. it means that the victim has the right to declare at any time that he or she has no longer wishes to exercise his or her rights as a victim in the proceedings. And the third, the classic procedural rights that you know about, these rights, to a right to present evidence, to make motions and observations, and you can see these rights in the slide. But the point is the next slide, because the victim has a right to pursue a civil claim as a private party in court proceedings, in criminal court proceedings. As you can see, the code does not expressly declare the victim's right to reparation or compensation. This is problematic because the right to a civil claim in criminal proceedings and the right to reparation is not the same. Nevertheless, some experts in Hungary list the right to reparation among the rights of the victims. But our proposal is that the code, the Criminal Procedure Code, should explicitly declare the victim's right to reparation. Oh, and the final subtopic would have been the characteristics of restorative and retributive justice, but I think that my time was over, so thank you for your attention. Thank you very much.
Thank you very much. You consumed your time, but it was extremely interesting, and I'm so sorry for my mistake, because presentation have been prepared, as you could see, by Dr. Ferenc and Professor Judith Jasko, who is our auxiliary member of the team. And right now I'm trying only to, could you, Ferenc, please stop sharing your screen, because like that I could share my presentation. Because I can see yours. And what is important, there are several questions on our chat that we had in our discussion. So we could discuss. Maybe Dr. Burja could help. Okay, now I think it works. Yeah. So I'm the last one to speak today, but I hope that you could stay with us a few minutes longer. So I will try to keep my time, and then I will open discussion even when some authors, so presenters, given the answers. But I think that it's extremely important to share directly our thoughts, and maybe it would be someone else who would like to join the voice. And as you see, I'm going to use almost the same all the time the same presentation, but not the same with added slide. I always add something new. And just to remind you of my previous main aspect of research, I'm going to inquire the theoretical aspect of mediation based on the general theory of law and philosophic conception, but not only, of course, presenting them on the example of Polish criminal procedure. And I hope also when I can read the papers of our Hungarian colleagues, I could add some part of my conclusion and formulate them based on Hungarian criminal law, criminal procedure, and regulation of mediation, which is extremely interesting, as you could observe, because it is only 4 years that the new code of procedure is binding. So it's a new regulation, and we see that the position of the victim is very well located in the code of criminal procedure in Hungary, which is crucial. So just to remind you, my 4 area of research are the general theory of conflict resolution and theory of communicative act approach, and the mediation as conventional act, and then contrary to duty obligation approach. And just to introduce to you the first part so general theory of conflict resolution. It is the most important part, because then we could discover the proper scope of mediation. And as we told several times, in Poland, mediation is not very well implemented, and in practice we could observe just a marginal significance of mediation. I have some data for you, and you can observe how it is even less than 1%. I suppose that it is more than it's like per mile. You will see, because I have whole data collected for today. So this first part, and I will keep with this part for today as well. Just to remind you, I discussed previously about the general approach about between retributivism and restorativism, because here we have to establish some basis for discuss and the place of mediation. And I took this compatibility approach. So I think that the field of criminal law, we have to combine restorative justice and retributivism. So it is impossible to go only for one way. Of course, it is very important which kind of model of prosecution is binding. And I'm still inquire this aspect about the position of mediation. And obviously, and I told it and I discussed about it previously, that how it is shaped at the basis of values, and where is the source of restitutive justice. And I have lastly, I observed the situation in non-inquisitorial prosecution, so adversarial model of prosecution. And my observation is that the position of restorative justice, and especially mediation, which is quite different than broader aspect of restorativism, because when speaking about restorativism, which Dr. Peno discussed today, it is a position of the community, society, which is involved in the negotiation process during the conferences, for example. Victim-offender mediation is rather stricter form without this aspect of community, society, which is represented only by in criminal trial, by criminal justice body, by prosecutor, following some rules. So speaking about the source of retributivism and mediation in adversarial procedure, I've observed that there are a large area of negotiation between prosecutor and the power of prosecutor during negotiation with offender to reshape responsibility following quite flexible rules. So discussing even the question of the extent of responsibility. And the position of victim in adversarial system is very fragile. Actually, it doesn't exist when it is before the indictment, when it's filed to the court. The victim has no voice at all. So I think that the reason why mediation and restitutive justice is so powerful in adversarial system is that the merge of negotiation for public prosecutor is very large, and the place for negotiation in normal situation, negotiated justice, is not existent. So mediation and in general restitutive justice create that space. And maybe it is a reason, it's my just hypothesis, so maybe for this reason it is so attractive. And to the contrary, it's not the same way when it is not adversarial system, which we could observe in Poland. So I'm still inquire this question, why it is not so attractive, as we could observe. Dr. Kowalewska is inquiring as well, why it's not attractive in our system, and what we could do with mediation. So and dealing with this, I would like to just go into my slide 13. Yes, 13. I'm here. Okay. I'm going to discuss today this conflict resolution theory and mediation. And for doing so, I'm going to implement this crucial aspect of the legal framework for mediation in Poland. So discussing different type of mediation. So first, I distinguish two types of mediation. So offender-driven mediation and victim-driven mediation. Obviously, I mean, speaking about offender-driven, this is some abbreviation, so-called abbreviation concept. So offender-driven mediation, it is the type of mediation when its offender is important, the most important. And as we could observe different typization, offender-driven mediation is more formalized. It's more settlement, so to achieve a settlement during mediation, maybe to create some benefit for offender by mediation as a reason, for example, of judicial discretion, which could be taken into consideration by a court. And victim-driven mediation is mediation flexible rules for mediation attached to, and even the formulas of legal actions are flexible. Communication is flexible, and it is not obviously settlement-driven. Mediation is just to restore the situation of victim and maybe to create a better space in the criminal trial. So two types of mediation I'm dealing. Of course, in Poland, in my opinion, is the first option. So offender-driven mediation, but speaking about some selected thoughts, because it's a very broad topic, the place of mediation could be, as Dr. Kowalewska, linked with the general formulas of negotiated justice, as we thought, consensual proposals institution. And today we discussed that maybe consensual proposals and institutions are more important from the point of view of defendant or prosecutor, and maybe it doesn't create the proper space for mediation. But I think that in Poland, in general negotiation, it's not very favorable for defendant, because there is any aspect of negotiation, because there are any benefits, special benefits for defendant, because the sanction is the same sanction. Defendant cannot negotiate the allegation, cannot maybe one institution, maybe we could discuss that institution later. So conviction without trial, but at the very early stage of pre-trial procedure, maybe this institution create a space for negotiation broader than the law allowed. So we can discuss maybe allegation at the first institution, but it is not strictly stipulated by law, but maybe by practice this is shaped like that. But in general, in my opinion, negotiated justice, it is connected with mediation, but rather the point of connection is in both so strict consensual institution and negotiation. It is the same that the defendant must not dispute the question of guilt, and must admit what she has committed at minimum. And as I told you at the beginning, my impression is maybe it is also the reason why mediation is not so frequent during pre-trial, because it needs to be admitted by a defendant. And for him, in an inquisitorial system, the question of admission of guilt is still open until the trial is validly concluded. So maybe this option is not very attractive for defendant, even in defendant-driven formula of of mediation. But I would like to just discuss with you some selected and maybe attractive issue that you could include into your research. So there are different formulas of mediation. And I mean, and one aspect is important, and this aspect have been stipulated also before. I'm going to discuss about the different formula of mediation, but firstly, inquiring why mediation could be attractive or not attractive for the given system. It is very important because Dr. Kowalewska stated today that victim offender mediation could be a tool to battle recidivism, so could be an institution in favor of non-reoffending. But I have some doubt about it, and I made inquiry because in general it is not stated in research, and I found one interesting research to this, and I would like to present you the conclusion. It is research quite recent from 2018, made by Maastricht scholars, but I cannot change the slide. I'm so sorry. I will try, but it not works. So, but trying to. Okay, where is this slide? Here. Okay, this is a research I would like to include today. So a discussion on research given by Van Dijk and the others. And he inquired the question about reoffending and mediation. And it was the first research, as far as I'm aware, when the four groups have been distinguished. And in the research, it was, in general, it were 1,300 cases, I suppose, in general. And there were four groups. First group, it was a direct mediation, the cases where the direct mediation had been performed. The second, indirect mediation, so the letters, exchange, flexible formula of delivery, some kind of messages between offender and victim. So direct mediation, indirect mediation. Third group, it was semi-mediation. So semi-mediation, it is very strictly connected with negotiated justice. There are the cases when perpetrator, defendant is interested about mediation, would like to be a part of mediation process, but victim has refused to go into mediation, or it is the group of cases victimless offenses. So the group semi-mediation is that there were some kind of mediation between prosecutor and offender, which means like some kind of negotiated justice. And the fourth group, it was the group of the case where defendant refused to go on mediation. The most important group was the third one, because there were the cases where when offenders were interested into mediation, but they couldn't go for mediation, and they couldn't have an access to mediation. And just to conclude, because the research is very interesting, and I think that I'm going to perform the similar research in Poland, because it is only research that we could fully estimate, by which we could fully estimate the question of reoffending, which is crucial for adopting mediation in criminal cases, from my point of view, because criminal law has some specific goals, and this goal of general prevention and individual prevention is very important, so we cannot ignore it. So as a conclusion, maybe to be short, I can read my chapter from this point of the research given, was that the offenders who were not willing to participate in mediation have a higher risk to reoffend compared with offenders who participate into mediation. So first intuition have been confirmed. But the offenders who are not willing to participate in mediation where the group had a similar result like the control group. So offenders who were willing to participate into mediation. So this creates because research has many features included, like personality of offenders and so on, cases, allegation, many features very important to properly establish the results. So in general, we cannot say that reoffending, the question of reoffending, is a pure result of mediation. We can rather discuss that there are some personal abilities of offenders, and those abilities are very important, and mediation is only a supportive process to doing so. So it is not direct benefit of mediation for criminal cases. And now, if I may, I would like to discuss with you two types of mediation, because we discussed about them. So mediation connected with adjudication, and mediation in post-adjudication period, because there are very important aspects, in my opinion, about two types of mediation connected with post-criminal procedures. So first of all, mediation could be performed before a judgment, of course, and could be included as one of reason of adjudicating, not of course mandatory for the court, but important for the court. And the second form of mediation, which I think is very important, it is mediation performed during enforcement procedures, so post-adjudicative mediation. Then I would like to include those forms, so direct mediation, indirect, and semi-mediation. And following Polish procedure, this is an example, very attractive to me. So the Polish Code of Criminal Procedure, it's enforcement code, I'm so sorry, create a space for post-adjudication mediation, but it is under discussion by scholars in Poland, because as you see, it is not very strictly indicated. It is Article 162, which is on the order on conditional release, and one of the condition is that the penitentiary court must take into account the settlement reached as a result of mediation. And in Polish criminal procedure, in general criminal law, is discussed whether this settlement, it is a settlement achieved before adjudication, or this article creates a separate and unique basis for mediation during enforcement stage. In my opinion, this is one of my result of my research. In Poland, this kind of mediation during enforcement procedure is very important to broaden the form of this kind of mediation. I'm arguing that it is authorized, and it could be because by this example we could truly implement and improve the situation of victims in criminal process, because even after adjudication, so we should exclude in this case the the motivation, not proper motivation, not acceptable motivation of offender why enter into mediation, because it is done. It is after adjudication process, after sentence, valid sentence which is enforced, and whether offender is interested into enter into mediation and discuss with the victim when everything has been concluded before, and by this kind of mediation creates a new space for the conditional release for offender. I think it could be very attractive, and it could upgrade the level in the numbers. It means when it comes to numbers. And for my last part of speech, because I want to take your time for too long, but to add just information that maybe could conclude our seminar as a whole, I would like to provide you some statistics about mediation. You must have in mind, bear in mind that in Poland there are, I think, I'm not sure, but recently I checked. Last year it was 2,070,000 cases, criminal cases registered by year. So not 3 million, but almost. And you see, we have only 3,040, about 40 several cases of mediation in 2020. So here we have the numbers from district courts in criminal cases. First, I'm showing the cases registered into the system. So you see the numbers are a little bit different than the cases directed to mediation, because when registered were 4,164 cases. In effective way to mediation went 4,079 cases. And from the number, only 2,569 cases have been concluded by settlement, and more than 1,000 no settlement, and 258 different conclusions. So without mediation result as the effect. And you see that the number is, we start from 400 in 2017, 4,000 2017, and 2020 it is 1,000 less than 4 years before. So we see that it is really a pitfall of mediation, and we have to challenge the situation. And there we have the statistics from regional court. So this is the court which is authorized to resolve the cases as a court of first instance in the case of felonies, because in Poland there's not exclusively mediation is not exclusively connected with offenses, with misdemeanors, so it is not this kind of limitation towards mediation. But it is not very large number of the cases. As you could see, the effective procedure of mediation have been performed 2017 22 cases, and then 2020 33 cases, but settlement only half of them. So we see that we need to improve the statistics, of course, and the practice. And just to conclude my speech, because I try to select my select topics, select issues to present for today. But I when I would like when I must denominate the reasons of those statistics and the practice of mediation, I can say what I said at the beginning, that in my opinion the position of mediation in Polish system, which is fully inquisitorial, it is the mediation is not attractive opportunity, neither for defendant, who is not willing to admit guilty until the final conclusion, nor for the victim, which is not interested to enter into this kind of interaction with a defendant, because it is, in my opinion, this offender-driven kind of mediation. I can just add that Polish mediation, it will be my last, where is it? Maybe here. Yes, this is a part of ordinance from the Polish, those provisions which are connected with mediation, and Magdalena discussed them before during our July meeting. We have this opportunity to perform indirect form of mediation, which is more flexible, so it is not necessary then the accused meet the victim directly. So it is possible to perform mediation by letters or so-called shuttled mediation, but I think that it is not very frequently used, this formula, and it wasn't inquired by any scholars, but made this form of indirect mediation, by improving the form of indirect mediation, could create the better situation for the victim, and maybe could create a better space to incite the victims to enter into procedure of mediation. So for today, I think I can conclude by this statement, and of course I will continue later. And just to mention, I'm going to discuss other theoretical approach, theory of communicative act or conventional acts, but rather by those theory, I would discuss the condition of mediation, how to perform mediation, of course, when accepting that this is optimal formula for resolving criminal cases. So I will go with those topics for during the next 2 seminars. Thank you very much for